And lastly, this case was also dismissed. This petition was also dismissed today, and this is the case of Falsis versus Civil Registrar General, GR number 2179. And lastly, this case was also dismissed. This petition was also dismissed today, and this is the case of Falsis versus Civil Registrar General, GR number 217910. On September 3, 2015, the petition sought to declare Articles 1 and 2 of the Family Code as unconstitutional, and as a consequence nullifies Articles 46, Paragraph 4 and 55, Paragraph 6 of the Family Code. While acknowledging that from the plain text, the Constitution does not define or restrict marriage on the basis of sex, gender, sexual orientation, or gender identity or expression, the court's decision dismissed Falsis' petition on account of his lack of standing, violating the principle of hierarchy of courts in failing to raise actual justiciable controversy. The court, through the ponente, Associate Justice Marvic M.V.F. Leonen, recognized the protracted history of discrimination and marginalization faced by the lesbian, gay, bisexual, transgender, queer, intersex, and other gender and sexual minorities, or the LGBTQI+ community. Along with their still ongoing struggle for equality, acknowledge that same-sex couples may morally claim that they have a right against discrimination for their choice of relationships, and that official recognition of their partnerships may, for now, be a matter that should be addressed to Congress. The court explained that judicial adjudication entails ruling, either in the affirmative or in the negative, on issues propelled by actual controversies. It clarified that it is only through the existence of actual facts and real adversarial presentations that this court can fully weigh the implications and consequences of its pronouncements. The court said, adjudication assures arguments between parties with respect to the existence and interpretation of fundamental freedoms. On the other hand, legislation ideally allows public democratic deliberations on the various ways to assure these fundamental rights. The process of legislation exposes the experiences of those who have been oppressed, ensuring that this be understood by those who stand with the majority. Often, public reason needs to be first shaped through the crucible of campaigns and advocacies within our political forums before it is sharpened for judicial fiat. The same decision cited Falsis and his co-counsels, Attorney Darwin P. Angeles, Attorney Kisha Trina M. Guangco, Attorney Christopher Ryan R. Maranan, liable for indirect contempt, explaining that to forget the bare rudiments of court procedure and decorum, or worse, to purport to know them but really only to exploit them by way of propaganda, and then to jump headlong into the taxing endeavor of constitutional litigation is a contemptuous betrayal of the high standards of the legal profession. In doing so, the court reminded that what we do in the name of public interest should be the result of collective decision coming from well-thought-out strategies of movement in whose name we bring a case before this court. Otherwise, premature petitions filed by those who seek to see their names in our jurisprudential records may only do more harm than good. Good intentions are no substitute for deliberate, conscious, and responsible action. Litigation for the public interest for those who have been marginalized and oppressed deserve more, much more, than the way that it has been handled in this case.